Good morning. My name is Beth Lifshin-Clark, and I am one of two deputy clerks here at the Appellate Division 3rd Department. This is Rob.
My name is Rob Marcioni. I am the administrator for the Family Court Assigned Counsel Program for the 3rd Department.
Today we're going to discuss the new rules, the new Appellate Division statewide rules that went into effect September 17th of this year, as well as the Appellate Division 3rd Department's local rules and the statewide electronic filing rules. As I mentioned, the Appellate Division rules went into effect on September 17th, and they are applicable throughout the 4 departments. Those rules can be found at 22 NYCRR Part 1250. We also have corresponding local rules at the 3rd Department, which are the Part 850 rules. And the electronic filing rules, the e-filing rules, are at 22 NYCRR 1245. All of those rules can be found on the court's website. If you go to the court's new rules of practice tab or the rules of practice tab, they're in 2 places on the website. You will find all 3 of those parts. And we're going to be going through some of the most significant changes as a result of the statewide rules, and then point out how the new rules impact assigned counsel cases. So the first thing I'd like to talk about is the implementation or the effective date of the statewide rules. And as I mentioned, the statewide rules went into effect on September 17th. And on September 17th, they applied to all matters that were commenced in the Appellate Division in which a notice of appeal was filed on or after September 17th. But they also apply to any pending matters on September 17th, unless the court directs otherwise upon a showing that application of Part 1250 would result in substantial prejudice to a party or would be manifestly unjust or impracticable. So what that means is, as of September 17th, the new rules apply to cases that are both with notices of appeals that have been filed, or even cases that have been perfected, but we're still waiting for respondents' briefs or even a reply brief. So they apply to your case as of September 17th if it's a pending matter. We're going to go pretty quickly through some of the specific rules and just highlight some of the most significant changes. If I can. So 1250.1 defines some of the general provisions and definitions that are significant for the part rules. And what I will point out as to 1250.1 is that it defines a digital copy, which we'll talk about in a little bit, which is required under the new rules, digital copy of documents filed. It also talks about the NYSIF system, and that deals with documents that are filed electronically through the New York State Court's electronic filing system, which we're going to be talking about quite a bit in a little while. So 1250 just provides some significant or important definitions which you should refer to if you're not sure how a phrase is used in the part. Let's see. 1250.1I speaks to e-filing rules, and I'll just scroll down. And it says that if there's a conflict between the statewide rules, the Part 1250 rules, and the e-filing rules, the Part 1245 rules, that the Part 1245 rules control. Moving on to 1250.2, there are some changes to this rule. It has to do, mostly having to do with when appeals are withdrawn or discontinued. So you should familiarize yourselves with those rules. It also specifically says under 1250.2C that the court needs to be notified when there is a change in circumstances. So if something happens where a case is settled or any other information the court needs to know about as to a change in circumstances, such as the case is now moot, the court needs to be notified. And moving on to 1250.3, this is the rule that speaks to the court settlement program. And one of the things that I want to mention is the fact that we now are using, as part of our settlement program, an informational statement form that replaces the previously used pre-calendar form, and this is required in all civil cases. So even in family court cases where it was not done previously, we now require you to provide the initial information statement.
Right, and Beth, if I could just jump
Yes,
in.
please.
Just to clarify, and the informational statement replaces the pre-calendar statement, so there's no need to submit both of those documents anymore. And the document is required even in abuse, neglect, and permanent neglect cases, cases that were not subject to the pre-calendar statement previously. They now do need to file informational statements for those cases.
And we do have that form on the court's website. So the initial information statement is on, the form is on the court's website under forms, right here. Initial informational statement pursuant to 1250.3A. So it is provided for you. 1250.4 speaks to motions, and they're not significant changes, but I will take this opportunity to mention that this is a good example of a rule that we have enacted a corresponding local rule for. So if you go to the court's 850 rule, you'll see that under 850.4, there is a corresponding local rule regarding motions. I will also tell you that the numbering system between the statewide rules and the local rules are corresponding. So it was purposeful that when we enacted the local rules, that if there was going to be a local rule corresponding to the statewide rule, it would be having a corresponding number system. So in the statewide rules, the motions are dealt with in statewide rule 1250.4, and we have a corresponding local rule at 850.4. Next.
And Beth,
Sure.
before you move on, I just, again, a couple of points of clarification as they apply to family court. When for poor person relief, for purposes of poor person relief on the appeal, Family Court Act 1121 requires that trial counsel either file a certificate on behalf of their client or help their client fill out a poor person application. That is very important in getting the appeal going. And of course, in terms of attorneys for children, the law states that they continue on the appeal unless they inform the court otherwise. And it's always helpful if family court attorney for the children notify our court as soon as possible if they won't be continuing on the appeal, so that documents are not served on them. It just makes the process a lot smoother for us to replace the AFC as soon as possible in the process of the appeal.
Thank you, Rob. Anything else regarding motions?
No, thanks.
1250 deals with methods of perfecting an appeal or a cause. Not much has changed for the third department in terms of how appeals are perfected, in terms of a reproducible record or the appendix method. You
Right.
want to speak to that, Rob?
Yes, because there is a significant change in the fact that under the statewide rules, appellants are given the decision as to what method they want to use to perfect. But the third department is requiring that family court appeals, for the most part, are still perfected using the appendix method. The assignment orders to assigned counsel will direct that they perfect by the appendix method. Of course, if there are cases in which the record is very, very small, that doesn't make sense, you can always request, and it's generally about 100 pages or less, you can request that the matter be perfected on the full record method prior, and the court grants that permission in many instances.
Do you have anything else to add about 1255?
I think that's it.
Okay. Moving on to 1250.6 is reproduction of records, appendices, and briefs. This is where you'll find helpful information in terms of paper size and paper quality and how it should be bound. Doesn't really require extended conversation, I don't believe. It does specify in subdivision E that you need to have the docket number, the appeal number on your, the cover of all of the briefs and the records and appendices. For any reason you don't have the appeal number, which you should, but if you don't have it, please call the clerk's office and we'll provide it for you. Anything about 1250.6 that you want to add? 1250.7 discusses the form and content of records and appendices and exhibits, and we do have a local rule on 1250.7 at 850.7. This rule goes through everything that needs to be included in the record and appendices. Want to talk about the 5531?
The 5531 statement is required to be in the record as well as the brief. And I will address 1250.7 a little bit as it pertains to family court appeals. As Beth mentioned, we do have a local rule, 850.7, that deals with a single copy of the record. The statewide rules actually don't require, when perfecting via the appendix method, to submit a hard copy of the record. Our local rule changes that, and the appellant is required to submit a single copy of the record on the appeal when using the appellate method. And by that, the appellant is required to certify to the single copy of the record on the appeal, not to the appendix as the statewide rules say. There's no need to certify to the appendix as counsel is certifying to the entire record on appeal. The record can be settled through affirmation, certification, stipulation, or order. Pretty much the way that it used to work. The record should be served on 20 days' notice to all of the parties. We don't have the same process as under the old 800 rules, where there is the notice and the certification pursuant to 800. If you certify the record after serving pursuant to CPLR 5525, that will suffice as certification of the record. So again, the record should be served seeking stipulation of the parties. If 20 days passes and the parties have not stipulated or expressed any concerns about the record, it can be then certified under CPLR 5525. If there are objections to the record or the parties cannot agree what should be included in the record, there is a little bit of a change. A motion should now be made to family court to settle that record and not to the appellate division. And I think that covers the significant changes there.
Great. 1250.8 discusses the form and contents of briefs. I don't think we need to go into the details in 1250.8, but I will mention that there are new limitations which are contained in subdivision, let's see, F2. It is now a word count as opposed to a page count. Appellants and respondents' briefs shall not exceed 14,000 words, and a reply in an amicus brief shall not exceed 7,000 words. So you should definitely be aware of that change.
And Beth, if I can also add, there is a new requirement in the new rules that along with the briefs, the counsel submit a printing specification statement in the document itself. A form can be found on the court's website. You'll find that at 1250.8J, and that is required. The court will not accept the document without a printing specification statement.
And again, as Rob mentioned, it's on our website under forms, right here. It's actually a couple places under forms, but the printing specification statement is available. 1250.9 has a lot of significant changes in it, so it'll take us a bit of time to go through that. The first thing that 1250.9 says is that an appeal must be perfected, except where the court has directed otherwise, must be perfected within 6 months of the date of the notice of appeal. So that's 1250.9A. Except where the court has directed that an appeal be perfected by a particular time, an appellant shall file with the clerk within 6 months of the date of the notice of appeal, or an order granting leave to appeal. So that's a significant change from what it was before. And again, because the new rules apply as of September 17th, if you had a notice of appeal that was filed before September 17th, but the case had not been yet perfected, and you previously would have had 9 months to perfect on September 17th, your time to perfect is now 6 months.
I will add, however, that with respect to assigned counsel cases in family court, under 1250.9B, the language states that except where the court has directed that the appeal be perfected by a particular time. Of course, all of our assignment notices do dictate a time in which the appeal should be filed. So the court has read that to take family court assigned counsel cases out of that 6-month requirement. So where otherwise a case would be automatically dismissed after 6 months if it wasn't under a current extension, that will not be the case with family court assigned counsel cases.
1250.9 also talks about the number of briefs and records and appendices that need to be filed with the court. So what is required is an original and 5 copies of the briefs, the reproduced record, or the appendix, as well as a digital copy of the briefs, record, and appendix. So that's a slight change. Well, it's a slight reduction in the numbers of brief and record that was required if it was reproduced record, but the additional digital copy is a new requirement under the new rules.
And if I could speak
Please.
to the digital copy a little bit. So the digital copy, the requirement for the digital copy can be found actually under the electronic filing rules at Part 1245, and the digital copy must comply with Attachment A of the electronic filing rules. Notably, the digital copies of the record, the brief, and the appendix must be text searchable and contain bookmarks. And if you need assistance with preparing these documents, certainly contact the court. Our IT department can assist you with creating those documents with your scanner and PDF program. The alternative is that you can also have those copies prepared by your local printer, by a local office shop like Staples or Office Max, and that is a reimbursable expense, just as making copies of your brief and record would be.
And I should add that there has been some confusion about the digital copy requirement versus electronic filing. So regardless of whether or not you have a mandatory e-filed case, you still are required to provide a digital copy as of September 17th of any brief, record, or appendices that you are submitting, even if it's not an e-filing case. So going back to the rule, if I can find it, this is where the rule is found that Rob mentioned earlier, I believe, regarding in the third department, it says that a digital copy of the complete record is required. However, we do have a local rule that also requires a hard copy of the complete record in an appendix method case. So it's both the digital copy and a hard copy of the record.
This is an important notice. Please at this time write down the following code: Z L E M Y 2 7 8 3. The code must be entered on the Certificate of Continuing Legal Education to receive CLE credit. Please make note of this code at this time. Z L E M Y 2 7 8 3. Thank you.
This subdivision B talks about extensions of time to perfect an appeal, and Rob mentioned this earlier. In general, this rule provides the parties can stipulate or an appellant can apply by letter to extend the time to perfect an appeal up to 60 days. But in assigned counsel cases where the court has directed otherwise, that those are different applications.
Right, different applications, again, the 6-month rule will not apply, so whereas in the ordinary civil case that's not perfected within 6 months, it's automatically dismissed, that won't apply. However, there is a slight change, again, because the initial assignment order directs that the appeal be perfected within 60 days or an application for an extension of time be made, because the deadline is set by court order. A stipulation can't be filed for more time. Counsel should request an extension by letter application on notice to the parties.
I will also mention that there is a local rule regarding this 850.9, extension of time to perfect an appeal, and it sets forth what is required. If you are making a motion, it has to be supported by an affidavit setting forth a reasonable excuse for the delay and an intent to perfect the appeal or proceeding with a reasonable time. Going back to the statewide rule, it also talks about respondents filing. This is another significant change. The rule says that a respondent on appeal shall file with the clerk within 30 days of the date of service of the appellant's submission, an original and 5 copies and 1 digital copy of the respondent's brief and appendix, if applicable. So your time as a respondent to respond is triggered by service upon you of appellant submissions.
Yeah, and I think what's significant about that for respondents is that the court is no longer sending scheduling letters as it had under the old rules. So your time to respond will run. If there is a glaring deficiency in the appellant's submissions, I believe you will be notified by the court if there is an actual tolling of your time to respond. But if you've been reserved with the appellant's record, brief, and appendix, I think the assumption should be that your documents are required within 30 days unless otherwise notified by the court.
The court is sending out a notice of filing, which will provide, when we receive an appellant's brief or record, we are providing a notice of filing, which will have the appeal number on it. But as Rob mentioned, it's not doing the scheduling demands as it was doing before. The rule also talks about the appellant's reply. And again, it's 5 hard copies and 1 digital copy, and that must be filed within 10 days of service of respondent's submission.
And again, just a note, and that time will run from the last respondent submission. So if there are 3 respondents in the case, 2 respondents in an AFC, whatever the last responding brief received or served upon the appellant is, that will start the 10 days to run for the time to respond for the reply brief.
This rule also says that under subdivision E, that pro se or unrepresented litigants are not required to file digital copies. And in that instance, they are, however, required to file an additional hard copy, unbound hard copy of their brief or an appendix or record, as the case may be, pursuant to a local rule. This rule continues to discuss cross appeals and concurrent appeals, and one of the significant changes in subdivision 3 says that if an appellant is taking an appeal for multiple orders and judgments arising out of the same action of proceeding, those appeals may be perfected together without a motion. And that is a significant change from how it was previously.
It is a significant change, and because a motion is not necessary, if a motion to consolidate appeals from multiple orders is made, it will be denied based on the fact that it's unnecessary. And I'd just like to jump back to the first two subdivisions in that, if I can, Beth.
Sure.
The first is cross appeals, a slight change from the way it used to operate. When parties have cross appeals, the parties should stipulate to a briefing schedule and notify the court. As before, parties should file a joint record, should agree on the record, and coordinate with that and file one record with the court instead of each party filing separate records. And concurrent appeals under subdivision 2 is the same. Appellants should perfect the appeals together without motion upon a joint record and brief when there are concurrent appeals.
Okay. Subdivision G discusses extensions of time to serve respondents' briefs, and the rule has built in that a party may stipulate or may apply by letter on notice to all parties to extend the time to file and serve an answering brief by up to 30 days, and to file a reply brief up to 10 days, and you can make 2 of those stipulations or applications. So built in, it's an additional 60 days that a respondent can be given to file the respondent's brief. After that, a motion is required. And again, we have a local rule at 125009B, which talks about the motion, what needs to show on a motion required under 1250.9G. You want to jump in on that?
I think you've covered it.
Okay. And I think that's the rest of 125009 that I wanted to mention. Anything else for that rule?
Nothing for 125009. 1250.10 is the dismissal of the matter. And again, I just want to underscore that this will not appeal to assigned family court cases on the appeal. That rule is different. If it is a retained family court appeal, the 6-month rule will apply, but only in family court cases where appellate counsel is assigned. Again, because that initial assignment order dictates a time for perfecting, we'll pull it out of that 6-month automatic dismissal rule.
So the rule itself says that if an appellant fails to perfect a civil matter within 6 months of the date of the notice of appeal, the order of transfer, or the order grants leave to appeal, as extended pursuant to 1259B of this part, the matter shall be deemed dismissed without further order. So it is definitely a significant change from the previous rules. It's something you should be aware of. B talks about the distinction with criminal matters, which we won't get into today, but there is also a local rule regarding 1250.10. 1250.10C talks about a motion to vacate the dismissal. So if you have a case that was not perfected and deemed dismissed pursuant to 1250.10A, this talks about making a motion to vacate the dismissal, and it must be made within 1 year of the date of the dismissal. It also sets forth what the motion must include in it to seek vacator of the dismissal. So the remainder of the statewide rules discuss other types of proceedings, like criminal, are specific to criminal appeals or original proceedings, workers' compensation, and so for this point, I guess we'll move on to talk about some of the more, the general e-filing rules. And as I mentioned, the e-filing rules are the Part 1245 rules. And those rules are also on our website. And if you go to the court's website, there is a link to e-filing, which will bring you to the court's e-filing implementation schedule. E-filing started in the appellate divisions as of March 1st. Each of the departments applied e-filing to different types of cases. In the third department, as of March 1st, we started with applying e-filing to those actions commenced by summons and complaint that originated in the third judicial district in which the notice of appeal was filed on or after March 1st. So those were subject to mandatory e-filing cases as of March. Those were the mandatory e-filing cases as of March 1st. We extended mandatory e-filing on April 1st to actions commenced in all of the districts in the department with notice of appeal filed on or after April 1st, as well as cases that were e-filed in the trial court, as well as cases where parties consented to e-file. And then on July 1st, we expanded e-filing as well in the third department to civil proceedings or proceedings commenced in county court, court of claims, surrogates court, and the notice of appeal was filed on or after January 1st. And in January, the next type of cases that are expected to be e-filed are family court appeals. So we thought we would go through some of the most significant parts of the e-filing rules, as well as show you how to access the e-filing website and provide hopefully some technical assistance in that manner. So the NYSEF website is, again, there's a link through our website, nycourts.gov/e-file. I'll go back to the rules. So 1245.2 of the e-filing rules talks about the courts designating what cases shall be deemed to be mandatory e-filing cases, and the appellate divisions will continue to extend what cases are subject to mandatory e-filing. And the first thing that needs to be done when a case is subject to mandatory e-filing is to register the notice of appeal or the transfer order with the NYSEF system. So that is how you get your appeal number, and that has to be done at very early stage in the appeal. So when you have a notice of appeal that you filed, and if it's a mandatory e-filed case, 1245.3 says that you need to register or confirm yourself as an authorized e-filer with the NYSEF system and enter the information that that is required under the NYSEF system within 14 days of the filing of a notice of appeal. So if you're not already a registered or confirmed registered authorized e-filer with NYSEF, I strongly would recommend that you do that right away, because when you do file a notice of appeal, you then have to register that notice of appeal with the NYSEF system within 14 days.
Right.
So want to go through the whole process, then we'll
Sure,
talk
we can go
about.
through the process. And we understand, again, registering with NYSEF is as easy as going to the site and just creating a username and a password that allows you to log on to the system. Again, as Beth mentioned, the e-filing system contemplates that the notice of appeal be filed within 14 days with the NYSEF system. And in registering with the NYSEF system, it's a matter of going in, uploading a copy of the notice of appeal along with the order being appealed from, and putting the information in regarding the cause that's being appealed and the parties involved, the attorneys who are involved. We understand that, especially in the early going, many of these notices of appeals in family court are not going to be e-filed by the trial attorney. So in many instances, the first paper that's going to come to the appellate division is the notice of appeal with the order and either a certification of continued eligibility, requesting counsel, or a poor person application. And then in the first instance, an attorney is going to be appealed to the case without the case having been e-filed. Having said that, it will then be the responsibility of the appellate's attorney to log on to the NYSEF system and upload those documents and initiate the process. And our assignment orders going forward will direct that if the case has not been registered with NYSEF, that the appellate attorney should do that within 14 days of receiving the assignment. Once the appeal is registered with NYSEF, and again, we're assuming here that the appellate attorney is the one who is going to register it, they will receive a confirmation email from the system giving them an appeal number. Now, again, in many cases, if the attorney has already been assigned the appellate division will have already given that appeal an appeal number. But for the purposes of NICEF, they will receive a confirmation email with the appeal number, which they will then be required to serve on all of the other parties by hard copy within 7 days of receipt of that email. Once the parties receive that notice, they then have 20 days, the respondent's attorneys, the attorneys for the children, they will then have 20 days to log on to the system and either register or confirm the registration and associate themselves with the appeal. And this is very important because once all of the parties are registered in the system or the requisite 20 days has passed, then service can now be accomplished through NICEF by uploading documents into NICEF. There's no further requirement to serve hard copies on the parties. So if there is a counsel who is representing a party in the appeal who has not registered within the system, they're going to be deemed to have been served when documents are uploaded without having received that notice from the system. So it's very important to log in within 20 days to confirm your participation in the appeal.
And as Rob mentioned, we understand that, and you're going to probably have an appeal number in these cases already, but the system requires us to start at that first stage of registering the notice of appeal and obtaining an appeal number. It's just the way the system is set up, so we can't skip that initial stage in the event that you already have your appeal number. So those rules that we just went through are at 1245.3. Sub B talks about the service of the notice of appeal number within 7 days, as Rob mentioned, and D talks about respondents entering their information within 20 days. 1245.4 talks about who is exempt from e-filing. In addition to the digital copy requirements, unrepresented litigants are also exempt from e-filing, and also attorneys who can meet certain requirements under 1245.4A2 are exempt as well. And there is a certification form up on NICEF as well as the court's website for those attorneys who believe they meet the requirements of being an exempt attorney.
And Beth, if I could just add that it is, however, the preference of the appellate division that cases be e-filed and that attorneys participate. And so attorneys that are part of our 18B assigned counsel panel or AFC appeals panel, it would be expected that they make every effort to e-file their documents. And again, our IT department is available to help you with any technical assistance that you need. They've helped very many attorneys thus far with the digital copy and the new requirements since September. So please contact the court and make every effort to e-file before you resort to opting out of the system.
1245.5 B talks about if you need to file and serve documents before the 20-day period for a respondent to enter their information pursuant to 1245.3. You can do that, but if you're going to file that before the 20 days has expired, you have to serve a hard copy on those respondents who have not yet gone in and registered that information. And as Rob mentioned, if you, as a respondent, do not go in and register within 20 days, after that 20-day period, service and filing upon all parties other than exempt attorneys is done by e-filing, and an attorney who has neither entered information nor given notice as an exempt attorney pursuant to 1245.4A2 shall be deemed served with any e-filed document. As Rob mentioned earlier, there is a attachment A to the e-filing rules that tells you how you have to format your documents. Those rules apply also to the digital copy as required under 1250.9 of the statewide rules. In addition, when you are e-filing a case, you are also required to file hard copies of your briefs and records and appendices. It's the same rules that apply to non-e-filed case. It's an original and 5 copies. So if it's an e-filed case, the e-filing satisfies your digital requirement, but you still have to do the original and 5 copies. Want to talk about motions? Under A12?
Under A12.
I should say A1, little I.
With respect to motions, again, once they are uploaded into the system, they are deemed to have been served on all the parties. However, there is a requirement that you file one hard copy, one original and one hard copy with the court.
1245.62 says that when you are filing your additional hard copies, you shouldn't do that until you receive an email notification the clerk has reviewed and approved the electronic version of the court and shall file the hard copies within 2 business days of the notification.
So I think notable there, Beth, is that in the e-filing system, as opposed to the current system, where even though the court requires a digital copy, perfection of an appeal is considered when the hard copies are filed with the court, and then the digital copy can be submitted after that. When e-filing, perfection is considered accomplished when those documents are electronically transmitted to NICEF, and then after those documents are received and approved by the court, then the hard copies can be sent in once you receive notification they've been approved. So perfection of the appeal is accomplished through uploading the documents to NICEF when e-filing cases.
But the appeal can't, that's true, but the appeal can't continue until we have the hard copies, so, and they have to be provided within 2 days. Similar to exempt attorneys under the digital filing requirement, if you are an exempt attorney or an exempt litigant, the court requires an additional unbound hard copy of the briefs and the record if you are not subject to e-filing. 1245.7, as Rob just talked about, in terms of when things are deemed served.
So the last thing I wanted to cover, Beth, was Rule 1245.3E, which is the designation of other persons or electronic filing agents. Under this rule, an authorized e-filer may designate another person to use their username and password to upload documents into the system. Remember, of course, that the e-filer himself or herself is ultimately responsible for those documents that are uploaded. An authorized e-filer may also designate another person or entity to upload documents through, if they are a registered e-filer themselves, is very often the case that a copy company will be a registered e-filer, and an attorney can designate that the copy company to upload the record and briefs in place of the attorney doing that. Again, the attorney himself or herself is responsible ultimately for those documents. And how we anticipate to see this play out with respect to family court appeals is that the transcriptionists who are responsible for transcribing the lower court hearings can be designated as agents for the attorney, and those transcriptionists will log on with their own username and password and upload the transcripts right to the NICEF system so that all of the parties will instantly have access to the documents, and we'll be providing more information on that.
I think that's all we have for the statewide rules, the third department's local rules, and the 1245 e-filing rules. I think the only thing that I'll add at this point is that if you have any questions, please don't hesitate to call Rob or the clerk's office. We're always available to help as much as we can. And then I think that is all we need to talk about. We will be going over, showing you some, providing you some helpful hints with Attachment A and the technical requirements, and going through some of the screens at the NICEF system, which hopefully will provide some guidance going through the e-filing process. Great.
Thanks, Beth.
Thank you very much.
All right. Hello, my name is Rob Marcioni. I'm the coordinator for the Family Court Assigned Counsel program for the 3rd Department.
And I'm Bill Nixon, head of IT for the Appellate Division, 3rd Department.
And Bill, why don't we go ahead and start off by navigating to the NICEF website?
All right, the easiest way to get there, you could use the link from the Appellate Third's website. Or you can just type in nycourts.gov/efile, and it'll take you to the NICEF, New York State Courts Electronic Filing System, login screen and welcome screen. We're going to go ahead and hit the appellate courts, and that will take you to a place where you can log in. If you don't already have a NICEF ID, it's a fairly straightforward process to go to the Create ID link, Create Account link, and follow the instructions on the screen. You'll use your attorney reg ID to create the NICEF ID, and you'll be given an opportunity to set your email address for service. If you have any problems creating the ID, there are help screens, and contact the NICEF Resource Center, the eFile Resource Center. All right, so we're going to go to the, well, first I'm going to log in, and I'm going to be Fred Smith, and I'm going to be the appellant in this case. Okay, so now we're going to file a case to the appellate division. We've logged in as Fred Smith, and we'll pick file documents to the appellate court. This link is the same as this file documents link, and we're going to go to appellate court. We're going to record initial case info, and to the third department. We use Albany County and Family Court.
And Bill, I'd just like to add that if you have an appeal from Supreme Court in IDV part, you should still enter Family Court on this screen. When you get to the following screen, you can select your case type, and then in case type description, you can add the fact that it's from IDV court.
Case type, the court number. In the case of having multiple index numbers from Family Court, put in the first index number. And I'm going to just make up a lower court index number, a lower court judge, the date on the order appealing from, the date the order was entered, and the notice of appeal date. And the date the notice of appeal was filed. And then it says, has this case been e-filed in the court of original instance? In the case of Family Court, the answer is going to be no at this time. If the answer is yes for any reason, basically what that'll do is it'll pull up the caption information from the lower court to give you a better starting point for this next page, where we enter our parties, the plaintiff petitioner. We're going to use Alex Miller. I'm just making up a name here. And Alex is going to be our appellant. And our defendant is going to be Ruth Miller. And she's going to be a respondent. And we're also going to add the children, Becky and Charles. that's good for our parties in this case. Our next screen gives you a summary of what the caption will look like. Based on your data entry order, you get the caption.
And there's no need to worry about the caption as it appears after you enter the information. One of the things that the clerk's office will do once that is e-filed is they will go in and create the short caption that will appear on the public website before it goes live. So there should be no concern that the real names are used and that it doesn't look like our appellate division captions usually look.
And then we'll click next to get our opportunity to upload our notice of appeal.
And Bill, if an appeal involves multiple notices of appeal and multiple orders being appealed from, because the system right now only allows you to upload one notice of appeal and one order, then if there are multiple notices of appeal, they should be combined in a single PDF and uploaded under notice of appeal. Same goes for the orders. The multiple orders should be made into one PDF and uploaded where it asks for an order.
Browse to our hard drive where we have that scanned as a PDF that conforms to attachment A of the appellate division e-file rules. Yeah, notice of appeal. There we go.
And Bill, when the appellate attorney is entering the notice of appeal, in most cases, they're already going to have an appeal number that has been assigned by the appellate division. It would be very helpful when you're uploading the notice of appeal to, in that box that says additional document information, to enter the appeal number that the appellate division has given this appeal.
And this check mark indicates that the document was sealed in the court of original instance by court order. It's not necessary to check that since all family court filings are confidential automatically by picking family court as the court type. So we'll go to next. And now our next step is to upload the copy of the order or judgment appealed from.
And again, Bill, if there are multiple orders that are being appealed from, they should be made into one PDF and that PDF uploaded here.
So we'll enter the order information here. We'll select copy of order, browse to our hard drive, find the PDF that has the order or multiple orders scanned into a single document. This additional document information is there shows up on the document list in NYSIF. If there's helpful information for the clerk's office that you'd want to add, that's your opportunity to do so. So that completes our initial entry. This will basically be enough information so that when this is submitted to the clerk's office, they'll be able to assign a case number. That completes the submission of the copy of notice of appeal and the order. At this point, it will go to the clerk's office to assign a case number. So we'll go back home. We'll await our case number, which will be served to you via your email associated with your NYSIF account and appear on the case when you look up the case.
And again, in many cases, an appeal number will already have been assigned because the case has been opened in order for the court to assign counsel for the appellant. But the clerk's office will retrieve that number that's already been assigned to the case, put it into the NYSIF system. That will be emailed to appellate counsel, and that will trigger the responsibility again to serve the other parties within 7 days with the appeal number and the fact that the matter has been uploaded into NYSIF.
The appeal number in this case is going to be 551231. When it's assigned, it gets posted to NYSIF, and also at that point, when you do a case search, you can look up the case via the case number. The appellant will also be emailed the notification of that assignment. So at this point, if I go into case search and I put in 55-12-31, I can see the documents that have been filed in this case.
So once the copy of the notice of appeal and the order being appealed from has been filed with NICEF, again, the appellate's attorney will receive the email from the system with the appeal number, then has the responsibility to serve that within 7 days. And so the next step is to upload the proof of service of notification of case number, and Bill will walk us through that now.
I'm going to file the proof of service of notification of the case number. And now we know that the case number is 55-12-31. And the document type here is proof of service of notification of case number. Which is right here. Proof of service of notification. And we'll go next. And that's all we're allowed to do at this point, so we'll go ahead and acknowledge it. And we'll wait. All right, so now we've received our notification of case number that was served upon us. I'm going to log in as the respondent attorney, John Jones, and enter my contact information for respondent and other parties. In my case, 55-12-31. And I'm going to represent Ruth in this case. The attorney for child will represent the children. So I'll just click represent, and it'll associate who I logged in as with the proper representation. And that's it for the respondent attorney at this point. The attorney for child was also served, so the attorney for child will also log in, register the contact information for the respondent in the same case. And okay, check the children that you will be representing, and then as the appellant role, select attorney for child. And click represent. And now that's all I have to do at this point as the attorney for child.
This is an important notice. Please at this time write down the following code: Y, R, X, Q, K, 6, 4, 2, 1. The code must be entered on the Certificate of Continuing Legal Education to receive CLE credit. Please make note of this code at this time. Y, R, X, Q, K, 6, 4, 2, 1. Thank you.
It is our anticipation that in family court assigned counsel cases, that the transcriptionist will upload the transcripts right to the NICEF system, so that all the parties will have access right away. This will be helpful, particularly with stipulating to the record. In order to do that, the appellant's attorney will have to complete an ADEF03A statement of authorization for electronic filing form, which will essentially allow the transcriptionists to file those documents right to NICEF on behalf of the attorney. So the appellant's attorney should complete this form and then give that form to the transcriptionist, who will actually upload that form to NICEF when he or she uploads the transcripts to the system.
You can find the e-file forms on the NICEF homepage. Over here in the resource tab, there's a forms link. And on that link, you can then go to the item 4, the appellate division forms, and you can find all the required forms for e-filing. So now I'm going to be that transcriptionist who's authorized on Fred Smith, for Fred Smith. And since Fred Smith has authorized me to be, to play this role, subsequent cases are covered under that authorization. It's a one-time requirement. So every time me as the transcriptionist have a case from Fred Smith that has to be uploaded, I'll use that same document as my authorization document. So I'm going to go in as my authorized agent transcriptionist and file to the appellate court, file to an existing appeal, pick my case number, and this will be non-motion documents, and we'll click next. Okay, as the transcriptionist, now I have an opportunity to select the attorney for which I am working. Here's a list of the attorneys I've already done work for. Fred Smith is not in the list. If I have, I do have Fred's attorney registration number because it's on the form. That's the easiest thing that I would put in as the transcriptionist. But I'll be Fred Smith and do a name search. And there I am. So I'm telling NYSIF that I'm doing this on behalf of Fred, and I am going to upload a transcript, which is all the way at the bottom. So browse, we're going to go to our transcript and upload it, and the additional information.
There, if there are going to be multiple documents, perhaps you could put the day of the proceedings in the additional document information line.
So we'll just say 12/31/18, which is interesting. So I get to the next screen, and it's going to ask me to upload my statement of authorization for electronic filing. So I'll go ahead and upload that document that I received from Fred. And at this point, I can also upload additional transcripts. If I have 5, 10, as many as you have an opportunity to upload all of them. So I'm going to just upload a second transcript. And yeah, put in that, and we'll go to next, and we're ready to acknowledge. So that completes the transcriptionist role of uploading our transcripts. And now Fred Smith, our appellant attorney, next step might be to file a motion in the case.
Why don't we go ahead and file a motion for an extension of time to perfect?
Alrighty, so I'm logged in as Fred Smith. And now I'm going to file to an existing appeal my motion. And this is going to be a notice of motion or petition under the motion documents on this side. And we'll hit next. Document type is going to be notice of motion. I'll browse to my attachment A compliant motion PDF. And at this point, that's what I want to do, so I'll hit my next. I have an opportunity to upload more documents if it's appropriate. So at this point, since motions typically cost $45, in order to have the system waive that, we want to upload that second document, which is the no-fee authorization letter, order, affirmation. In this case, it's going to be the order from the appellate division assigning counsel.
Correct.
So when you want to do that in this step, so in the next step, it doesn't ask you for a fee. So we're going to enter assignment of counsel order is going to serve that purpose for the no fee authorization. And when we get to the next button, it's going to ask us what is the main relief sought is going to be extend time. And it's asking us for the return date.
And the return date, motions are always returnable on Mondays here at the appellate division. And it's always 8 days from when the documents are being served. Obviously, in this case, because as soon as that motion is filed, the other parties will be served electronically. There's no need to add the 5 days as is typical in a notice of motion that is mailed. So the appellant's attorney or whoever's filing the motion should select a return date that's on a Monday and at least 8 days out from when the motion is being filed with NICEF.
Okay, so today is a Monday, so I have to go to the 14th,
Correct.
right? 2 Mondays away. And we'll hit the next button. Here it's prompting for fee if applicable. Since it's not, we can hit the no fee button. And you notice this is where it says the no fee authorization letter is required. It assumes that you did it in the previous step, and we did, so we'll hit next and check our author, acknowledge that I've read and understand the following, and we'll file those documents.
So Bill, let's look at now how to upload the proposed record on appeal. We have had the system configured so that the proposed record can be served on the other parties through the NICEF system. Keep in mind that the transcripts, we anticipate that they'll be uploaded by the transcriptionists, but at the end of the day, it will be the appellant's attorney's responsibility to make sure that the transcripts are uploaded into NICEF. And now we will walk through how to serve the proposed record on appeal through the NICEF system.
Okay, Rob, once again, we're going to go to the NICEF system, log in, and we're going to file documents to the appellate court and file to an existing appeal. And in this case, it'll be a non-motion document. And we want to just find the proposed record on appeal. I'm going to hit P to go to the first of the P's in the list. And I see proposed record on appeal right there. So once we find it, we're going to go ahead and upload that document type and submit it just like we did with the motion. When we hit next, we'll get prompted for more documents if you have them. And we'll go next once again, do the acknowledgement, and file the document. Once this document is filed, an email service will be sent to the parties in the case, which is the proof of service for NICEF. Anytime you upload a document, the service is done through NICEF.
Correct. And when the proposed record on appeal is uploaded, the court will not be notified. The parties will receive service, but the court will not be notified. And then when the actual record on appeal is uploaded later on, our clerk's office will go back and remove the proposed record on appeal from the file.
Okay, that takes care of the proposed record on appeal. Period. Okay, so now we have our opportunity to perfect our appeal and submit the record and the brief. And it's important that we select the record on appeal as your first document. And you really want to submit both documents in this step. So I'm going to find my record on appeal here and upload that. And we'll go to our next screen where we can upload the brief or the brief and appendix, depending on your perfection method and whether you have 2 documents or 1. On this second screen, we have our appellant's brief. So in this case, we'll pretend I've got an appellant's brief as 1 volume and an appendix as 1 volume. Those can all be submitted as separate files during this second screen where you have the opportunity for multiple documents. So any documents that are related to the perfection documents should be uploaded at this point. So now I'm going to pick my appendix, and in this case I've got 3 documents that were submitted to the court in bound paper volumes, a record, a brief, and an appendix. So now there's our appellant brief. Now we're going to grab our appendix and we'll complete the submission. That's all the documents I wanted for this step, so I'll hit next. And since I've already uploaded my no-fee authorization form in a previous motion, this case, NYSEF knows that there are no fees associated with it. So I can just check no fee and click next. Then we have our summary of what we're submitting. You see the record on appeal, the appellant's brief, and the appendix. If your brief and appendix were 1 bound volume, this would say brief and appendix instead of 2 separate documents, so that your paper documents always match your electronic documents. So now I'll acknowledge these things and file my document. So now, as the respondent, John Jones, I'm going to log in and submit my respondent brief. So I'm logged in as John Jones, go to the appellate court, and now I'm going to file to an existing appeal, and this is going to be a non-motion document. And my document type is going to be the respondent brief. And if I had other documents, this can all be done at one time, or if you choose to log in multiple times to do it, whatever is appropriate for the case. So there's my respondent brief. And I am done. So I don't have any additional documents.
And this is the way the attorney for the child would file his or her brief as well.
And at this point, we have a fully perfected case that will be scheduled for a term of court.
And then when the court ultimately issues a decision and order on the appeal, that will also be uploaded to NYSEF, where it will be served on the parties. And if the appellant wants to file a reply brief, they would walk through the system and take the same steps as we just saw, just selecting reply brief instead of responding brief. That concludes our training on using the NYSEF system to e-file a case and all of the components involved. Certainly, if you have any questions or we can help, please feel free to contact the court at any time.